Okay, are we on the record?
Yes, sir.
Thank you so much. This is the case of the State of Ohio versus Nicholas Tillard. I hope I'm pronouncing that correctly. It is case number 23CR164. Would counsel enter an appearance, please?
Yes, Your Honor. On behalf of the State of Ohio, Adam King, Assistant Prosecutor.
Good morning, sir.
Good morning, Your Honor.
Good morning, Mr. Tillard.
Morning.
Can you hear me okay?
Yeah.
If at any point in time you can't hear, please wave at us, yell at us, do whatever you need to do, because it's important that you be able to hear everything.
Gotcha.
Mr. Tillard, do you have a lawyer in this matter?
No.
Okay. I know you're incarcerated. I think your out date is coming up here end of February next year. I'm going to make an assumption that you don't have the means to hire a lawyer. Is that accurate?
Correct. I already filled out a paper for a court-appointed attorney.
Good enough. I am not from here. I'm from Columbus, so what I'll do is I'll talk to some of the folks here, and we will appoint somebody locally here to represent you. Our purpose in being here today is for an arraignment. Do you need a lawyer before we can go through this preliminary work at the arraignment today?
No.
Okay. Sir, have you received a copy of the indictment?
Yeah, I threw it out though.
And how far back did you receive that? Do you know?
September 28th.
Okay, good enough. If you want, we will read that indictment to you here in the courtroom, or you can waive that reading.
No need.
Okay.
No need to.
We need to make a record, though, so I'm simply going to explain that you're charged with one count of assault. It suggests that on May the 3rd of 23, you did knowingly cause or attempt to cause physical harm to a peace officer. I need to make sure you understand the nature of those charges. Sir, I'm going to ask you at this point to enter a plea, and I really think the only plea you can enter at this time would be not guilty. Is that your intention?
Yep, not guilty.
Okay, good enough. Mr. King, anything on the record from your point of view?
Just the only thing from the state, Your Honor, would be in regards to bond. The state would ask that bond be set in the amount of $5,000 in this matter. I would also make the court aware that the defendant has filed a request for a speedy disposition of this case. It was received by the state on November 9th. It looks like the defendant filled this form out on November 2nd. So I did just want to make the court aware of that. It's my understanding once this has been filled out that the defendant shall be brought to trial within 180 days after he causes this request to be delivered to the state. That's all, Your Honor.
Okay. Mr. Tillard, you were able to hear all of that, is that correct?
Yeah.
So this paperwork that you have filled out indicates you're requesting that you get a speedy trial under that statute. That means that to be safe, from the point where you filled the form out, which is November 2nd, we need to bring you to trial within 180 days. You understand that?
Correct.
Okay. Was there anything you wanted to say about bond, sir? The state's asking for a $5,000 bond. I wanted you to have any input on that you want. Are you able to hear me, sir?
Oh, me? Yeah, I mean, it don't matter to me. I'm in prison. What's a bond
I
gonna
understand that
do?
part, sir. I'm simply trying to make a record and give you a chance to tell me what it is that you want to tell me. Okay, the court is going to set the bond at $5,000 cash, property, or surety. I'm going to order that you not leave the state of Ohio. Bond is to be posted in the defendant's name only. Defendant shall have no contact directly or indirectly with the victim in the case. From the state's point of view, is there anything else that we need to do to complete this arraignment?
The only thing I can think of, Your Honor, I didn't know if you would like to go ahead and set a pretrial date, a date for a pretrial hearing, set a trial date, if you would like to do that at this time. Or
Yeah, I want to do it however it is you folks do it here.
that's typically how it would be done, Your Honor.
Here on the record?
You would appoint, you would set a pretrial, set a jury trial, and appoint counsel. I realize at this point you don't know who your options are to appoint as counsel, but that's all I can think of that remains to be done, Your Honor.
Okay. Why don't you make some suggestions then, based on your normal practice here, understanding that we have 180 days from November 2nd?
My suggestion, I thought, would be to have Ms. Sawyer come out with her calendar, the assignment commissioner, so we can reference that, and also I'm not sure what your availability is, Your Honor, but that would be my suggestion.
Okay. Can we accomplish that? Mr. Tillard, we need to pick a couple dates here, so if you're patient with this, we should be done here in a few minutes.
Also, Judge, here's a list of attorneys.
We'll blame him.
Here's attorneys.
Okay, I've been provided with a list of lawyers apparently who take local appointments here. The only name on the list that I am familiar with is Jeff Blosser. I am picking a pig in a poke with anybody else.
And I don't see any reason why anyone on that list should be an option. The only name I would possibly not use would be Catherine Haffner, because she was present in the courtroom representing the defendant when this alleged incident occurred, so she would be a witness. But aside from her, I would imagine that any attorney on that list would be perfectly suitable, Your Honor.
Thank you.
What do we need to set, sir?
Well, we need a trial date. Let's see, November, December. We need a trial date before May 2nd, and we need a pretrial date 30 days before trial. Is that?
I would prefer a pretrial sooner than that.
Okay.
Sir, I'd like to have this all concluded before I am released from prison, if possible. That would be,
That's the end of February, the 27th. Is that correct?
yep. Normally Highland County does things pretty quickly.
Okay. Well, I'm happy to do it as quickly as I can.
Could we have a pretrial potentially in January, Your Honor?
What day in February was he released?
Yeah, my January, I have a jury trial scheduled virtually every single week in January. How about a pretrial, February 5 or 6?
So February 5th would probably be preferable. February 6th is grand jury.
February 5th?
Yes, sir. That's it. What time would you like, sir?
Is 11 o'clock okay?
Yes, sir.
Can we set a trial date then for the 26th? I don't know what days you normally
Yes.
start here. Mondays?
Yeah, that'd be fine, Your Honor.
And what time do you normally start jury trials?
8 a.m.
Okay, Mr. Tillard, I'm assuming you could hear all that, but we're going to have a pretrial on February the 5th at 11 in the morning. We're going to have a jury trial on February the 26th. I believe I'm going to appoint Attorney Jeff Blosser to represent you. He should be in touch with you. Now, anything else from the state?
Nothing else I can think of, Your Honor.
Okay, Mr. Tillard, was there anything else you wanted to bring to my attention at this point?
No.
Okay. I would set your trial sooner, but I am scheduled with trials all the way through the month of January and February. I will be happy to get a hold of the lawyers if one of those trials goes away and I have an opening, and we could try and get yours done sooner, but we will have to wait and see what happens with those other trials. Unless somebody has something else for me, I want to thank everybody.
Nothing else, Your Honor.
Mr. Tillard, take care.
You too.
All right, are you Austin Taylor there at the jail?
Yes, Your Honor.
All right, it's case number 23 CR 169, State of Ohio versus Austin J. Taylor. Mr. Taylor's appearing by Zoom from the jail. His attorney, Jacob Wagner, appearing by Zoom, looks like on his phone, and appearing on behalf of the state is Assistant Prosecutor King. Defendant is charged with 2 counts of rape and gross sexual imposition. This is a final pretrial trial set for December the 4th. Now, I see there's a stipulation here for a polygraph, but before I get to that, other than that issue, is all the discovery complete?
It is from the state, Your Honor.
Likewise, Your Honor.
All right. And there's no pretrial motions pending, correct?
Correct. No, sir.
All right. And you do have the written plea offer?
It's been relayed, yes.
Okay, all right. So, let's see here. Looks like it's been signed by everybody, all right. So, Mr. Taylor, I have here a proposed agreement and stipulation that is for you to take a polygraph administered by the Highway Patrol. They don't know the polygraphist yet. To be done on the 17th of November, 2 days from now, at 8:30 in the morning in Columbus. And I see on the back page, it looks like a signature, Austin, there's a signature line, Austin J. Taylor. I'm going to hold that up there to the camera and ask you if you recognize that signature.
Yes, Your Honor, I do.
And is that your signature?
Yes, Your Honor.
And when did you sign this agreement?
It was a while ago. I can't remember the exact date.
Okay. All right, well, generally, Mr. Taylor, a polygraph is not admissible at a trial, but there is a provision that allows the parties to agree and to stipulate to the admission of the test, and that means that the results would be admissible of the test, whatever the questions were, and the polygraphist's opinion as to your reaction to those, whether you were truthful or not truthful. Now, if you pass the polygraph, doesn't mean that you are automatically have a case dismissed. And likewise, if you are determined that you did not pass it, it would not automatically mean you would be guilty. It's simply another piece of evidence that could be admitted for the purpose of showing, whether you were truthful at the time of that test. You understand that?
Yes, Your Honor.
All right. And you wish the court to go ahead and approve this here today and have you take the polygraph on Friday, I guess would be?
If you would, Your Honor, yes.
All right. All right, well, then the court then approves that, and I'll file it, and we'll wait to see what will happen after that. There's no other hearing scheduled, so I would ask the counsel to notify the court if there's a need for further status conference before the trial date. All right, anything further from counsel?
No, Your Honor.
All right, thank you.
Thank you, Your Honor.
All right, are you James Williams IV?
Yes, Your Honor.
Okay, this is case number 22, CR 189, State of Ohio versus James Williams IV. Mr. Williams is charged with 1 count of aggravated possession of methamphetamine, a 5th-degree felony. This is the first pretrial, final pretrial set for December 13, and a trial date is set for January 4. I've been presented with a plea of guilty form, Mr. Williams, which indicates you're going to withdraw your non-guilty plea guilty to this charge. I'm going to hold the first page of that agreement up to the camera and ask if you can identify, do you recognize that agreement, that page? All right, and on page 3, there's a sentence about a fourth of the way down the page. It reads, "I enter this plea voluntarily." And right below that appears to me to be the signature James Williams. I'll put that up to the camera and ask you if that is your signature.
Yes, Your Honor.
When did you sign this agreement, Mr. Williams?
This morning.
All right, before you signed it, did your attorney go over with you and explain everything to you?
Yes, Your Honor.
And did you understand that's an agreement to plead guilty, which means there won't be a trial? The next step in your case will be a sentencing hearing?
Yes.
And do you feel you had enough time to fully consider the matter before making the decision?
Yes, Your Honor.
And did anyone pressure you in any way to get you to sign this document?
No, Your Honor.
Did you sign this agreement voluntarily?
Yes, Your Honor.
And you still want to go forward with it here this afternoon?
Yes, Your Honor.
All right, it says you're going to plead guilty to the charge of aggravated possession of methamphetamine under 2925.11, a 5th-degree felony that carries a possible term of incarceration between 6 and 12 months, fine of $2,500, and a possible license suspension of 6 months to 5 years. You understand that?
Yes, Your Honor.
Are you facing any felony charges in any other jurisdiction?
And Clinton County,
For what?
F5 drug possession.
All right. Well, if you were convicted of both of these offenses and sentenced to a term of incarceration, the term of incarceration in each case could run consecutively, meaning one after the other. You understand that?
Yes, Your Honor.
And other than that case, are you currently, in this case, are you currently on probation or community control, parole, or post-release control in another case or in any other jurisdiction?
No, Your Honor.
All right. Now, in the event you're convicted of these offenses, and if you should be sentenced to a prison term, then upon completion of that, the Adult Parole Authority could put you under post-release control for a period of up to 2 years, and if they did, you'd be supervised by a parole officer in the terms they set. And if during that period of time you violated those conditions, they could return you to prison and make you serve an additional period of up to 9 months for a single violation, up to a maximum of half of your prison term for all violations. But if you commit a new felony, then in addition to whatever sentence could be imposed by the judge in the new case, that judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year, whatever time's left on that period of post-release control, whichever is greater. And if that occurs, that has to be served consecutively a sentence in the new case. Do you understand that?
Yes.
Now, under the law, I'm not required to sentence you to prison for this offense. I can impose what's called community control or non-prison sanctions. That means instead of going to prison, you'd be put under the supervision of a probation officer on a term set by the court for a period of up to 5 years. If during that period of time the probation department felt that you're not complying, they would file a written notice out with the court. You'd get a copy. There'd be a hearing. You'd be entitled to have an attorney. The outcome of the hearing was if you failed to comply, then at that time you could have your community control revoked and be sentenced to between 6 and 12 months of incarceration and fined $2,500. You understand that?
Yes, Your Honor.
Now, the charge in the indictment alleges that on or about April 25, 2022 in this county, you knowingly obtained, possessed, or used a Schedule II controlled substance, methamphetamine. And so that's the charge, 5th-degree felony, under 2925.11 of the Higher Revised Code that I've explained to you earlier. Do you understand the charge and the possible penalties?
Yes, Your Honor.
And do you, have you discussed the charge in the indictment, the evidence, possible legal indictment, the evidence, possible legal issues, the possible defenses you might try to raise at trial, and possible outcomes of a trial with your attorney?
Yes, Your Honor.
Are you satisfied with her advice and competence in this matter?
Yes, Your Honor.
Are you under the influence of any types of drugs or alcohol at this time?
No, Your Honor.
Has anyone threatened you to make you plead guilty here today?
No, Your Honor.
Now, page 2, there's 2 sentences that are printed in bold and underlined that read as follows: defendant will enter a plea of guilty to the indictment, state defense, jointly recommend community control, and referral to drug court. Is that your understanding of the agreement?
Yes, Your Honor.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, Your
Under the law, the matter of sentence is not up to the parties, it's up to the judge. And so even though there's an agreement that you should be given community control or probation, that's not binding on the court. So once I've heard all the information presented, I could decide that's not the correct sentence, that you should be sentenced to a term of incarceration of 6 to 12 months. Could be fined $2,500. You could have your license suspended for 6 months to 5 years. You understand that?
Yes, Your Honor.
All right. Now, you have certain constitutional, let me back up. Do you hold any license or certification from any state governmental agency for any occupation or profession?
No, Your Honor.
All right. Now, you have certain constitutional rights you must understand. Before I can accept your plea, first you have a right to have an attorney, and Ms. Witt was appointed to represent you. That wasn't simply to work the case out, but to provide any defense that could be available to you under the trial that you would like her to provide. So if you decide you do not want to do this, she'll continue to represent you, including a trial, if that's what you want. You understand that?
Yes, Your Honor.
Right now, under the Constitution, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that are that live in Highland County that are summoned for jury duty on your trial date. After they are selected, the evidence would be presented, they'd be instructed on the law, and then that jury would have to decide by unanimous verdict whether or not the state proves your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive in writing, which means you give up your right to have a jury trial, and in that case, you would have what's called a court or bench trial, meaning that instead of a jury hearing the evidence, the judge would hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proves your guilt. You understand that?
Yes, Your Honor.
Ben, would you go give me the calendar? All right, now, under the Constitution, you have a right to confront the witnesses against you in open court and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into court, testify in front of you, your attorney, and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination, and the purpose of that is to try to bring out evidence that would help your side of the case. Do you understand that?
Yes, Your Honor.
Now, under the Constitution, you have a right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order that's a subpoena, and that forces those people to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come in and testify against you. You understand that?
Yes, Your Honor.
Okay, now under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. It's your decision. If you decide you're not going to testify, the fact that you did not testify cannot be used against you in any way by any person, and no one's even allowed to comment about it except in one situation. There's a jury trial and you don't testify. The judge instructs the jury that because it is your right, they cannot consider it for any purpose. Do you understand that?
Yes, Your Honor.
Now, under the law, you're presumed innocent of this charge until proven guilty by the state of Ohio on every essential element of the offense charged. So, the burden of proof isn't on you to try to prove that you're not guilty simply because you've been accused. In fact, under the law, you're not required to present any evidence at all at trial. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. You understand that?
Yes, Your Honor.
All right, now originally you entered a plea of not guilty. Not guilty plea denied the allegation in the indictment, denied you committed any crime, and exercised or invoked all the rights I've just described. You change your plea from not guilty to guilty, that is the complete opposite of not guilty plea. The guilty plea admits the allegation in the indictment, admits that they're a crime, that you are the one who committed that crime, and that plea waives or gives up all of the rights that I've just described for you today, except the right to have an attorney. You always have a right to have an attorney no matter what your plea. But with that exception, your plea of guilty would waive or give up your right to a jury or court trial, waive or give up your right to confront witnesses against you and cross-examine through your attorney, waive or give up your right to use the power of the court to compel or force witnesses to come to court to testify on your behalf, the same as the state. Would waive or give up your privilege against self-incrimination because you're the one saying you're guilty, that's what's used to find you guilty. Would waive or give up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives or gives up any right to file an appeal on any alleged violation of your rights you feel may have occurred up until this point. Now, if I should sentence you to the maximum sentence or under other limited circumstances you could file an appeal, that would have to be filed within 30 days of your sentence and entry being filed. Do you understand that?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Now, do you have any questions about the charge of the possible penalty?
No, Your Honor.
You understand it?
Yes.
Have any questions about the plea agreement?
No, Your Honor.
You understand it?
Yes.
You understand that the sentencing recommendation is not binding on the court?
Yes, Your Honor.
Have any questions about the constitutional rights I've explained?
No, Your Honor.
You understand those?
Yes, Your Honor.
You have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No, Your Honor.
You understand?
Yes.
Now, is there anything, I didn't tell you this earlier, but if you need to speak with your attorney, I can put the two of you into a breakout room and you could speak with her privately without anyone else hearing you or seeing you on the screen, and the deputy would step out during that time. You understand that?
Yes, Your Honor.
Do you have any need to talk to her about anything?
No, Your Honor.
I think I also neglected at the beginning of the hearing, but Ms. Witt, you and your client both agree that this matter can be conducted by Zoom rather than his in-person appearance before the court.
Yes, we do.
And you're all right with that, Mr. Williams, that we're doing it this way?
Yes, Your Honor.
All right. Then, Mr. Williams, is it your decision to go forward and plead guilty according to the terms of the agreement we just went over?
Yes, Your Honor.
All right, then as to the charge, it alleges that on or about April 25, 2022 in Highland County, Ohio, you did knowingly obtain, possess, or use Schedule II controlled substance with methamphetamine in violation of Section 2925.11 of the Ohio Revised Code, 5th degree felony, carrying possible penalties of 6 to 12 months incarceration, a fine of $2,500, and a license suspension of 6 months to 5 years. How do you plead?
Guilty, Your Honor.
All right, the court finds on this day the defendant was advised of all his constitutional rights, made a no intelligent voluntary waiver of those pursuant to Criminal 11. Pleas accepted and order filed. Defendant is found guilty of the charge as set forth in the indictment. The court orders a pre-sentence report which shall include an assessment for substance use disorder, treatment, and or mental health. Case is also referred to the drug court docket for consideration for application into that program. Sentencing will be set for December 13 at 9 a.m. and bond will be continued. Is there anything further from counsel?
No, Your Honor.
All right, thank you. Alan Shoemaker is next. All right, are you Alan Shoemaker appearing there from the jail?
Yeah.
All right, we have two cases involving Mr. Shoemaker, both styled State of Ohio versus Alan W. Shoemaker. Case number 23-CR-151, in which he's charged with 2 counts of violating a protection order or consent agreement, and 23-CR-207 and is charged with the same offense. This hearing is being conducted by Zoom, and his attorney is Danielle Witt. She's appearing from her office. Appearing on behalf of the state is Assistant Prosecutor King. Now, Mr. King, has the alleged victim of these offenses been notified of the time, place, and purpose of the hearing, the right to be heard?
Yes, Your Honor, is elected not to appear.
All right. Now, in case number 151, this is a final pretrial, and the trial date is set for December 4, I believe. And then this 207 case was just indicted last week on the 7th, and that is a first pretrial at this time. And I'll also note that the defendant is under a PRC, according to notification I received on the 9th. All right. Now, In the newer case, I believe there's been a request for discovery. Looks like the state provided discovery yesterday. Ms. Witt, that discovery will be due by the final, your discovery will be due by the final pretrial, which is currently set for December 13, and a trial date on January 8th. Now, with regard to 151, which is set for trial next month, is the discovery complete on that?
It is from the state, Your Honor.
All right. Ms. Witt?
Your Honor, I have not filed a compliance yet. Actually, in meeting with Mr. Shoemaker this morning, he demanded that I withdraw from his case and cease communications with me about his case. So I have not proceeded any further at that time.
Okay. What's the problem, Mr. Shoemaker?
Nobody wants to listen, so, I mean, when I make a statement and turn around and get told completely opposite of what I just said, so, I'm done.
Well, if you want another attorney, you know, you can hire another one if you want. But you know, since I appointed her, you know, you can't fire her. Only I can fire her, and I don't fire attorneys just because the defendants don't want them to represent them anymore. Because you know, that's just used as a tool by a lot of people. And so, you know, I'm not going to let her withdraw because we have this hearing and that trial coming up in 2 weeks. Well, a little over 2 weeks, about 3 weeks, a little less than 3 weeks. And, you know, that would mean I'd have to continue the case, which I'm not inclined to do. And you wouldn't have an attorney, which is a big mistake. So at this time, I'm not going to permit her to withdraw. We're going to go ahead and proceed with this trial. So you need to cooperate with her. And, you know, if you don't want to cooperate with her, that's up to you. But that'll be on you. That won't be on her. And so, you know, if you have witnesses that you feel can testify regarding this matter, you need to let her know so that she can get them subpoenaed and can disclose those to the other side. All right. So, are there any other matters that need to be discussed at this time?
Nothing from the state, Your Honor.
All right.
No, Your Honor.
All right. Thank you. Sharon Kennedy is next. Sarah Kennedy, I should say. Okay, come on up. We'll go ahead and do Mr. Riffle. Mr. Riffle, come on up and have a seat. We're going to do Mr. Riffle since he's here in the courtroom. And Ms. Hafner needs to get downstairs. All right, this is case number 23 CR 199, State of Ohio versus Sheridan Riffle, Delano Riffle. And you're Sheridan Delano Riffle? Yes, sir. Mr. Riffle is present in the courtroom with his attorney, Catherine Hafner. He came here rather than having a Zoom hearing. I understand he came from Greenfield. And Mr. King's representing the state. He's appearing by Zoom. Mr. Riffle, Mr. King, had the alleged victim of these offenses been notified of the time, place, and purpose of the hearing, the right to be heard?
Yes, Your Honor, and is elected not to appear.
All right, thank you. All right. So Mr. Riffle is out on bond, I take it now, because we had a bond reduction hearing, I believe, earlier in the week. All right, and so I think that's why we set this matter so quickly. Set for he's charged with burglary, safe cracking, and theft, and was arraigned, I believe, last Thursday. And the matter is set, as I said, fairly quickly. The trial date set for the 4th of December, and final pretrial is next week. So now that he is on bail, that would alleviate some of the time constraints. And so have you had a chance to do anything on this case yet?
I filed my demand for discovery this morning. I have not received the discovery yet. Did receive a plea offer, which I just now communicated with my client. So we probably do want to slow it down a little bit now that he's out on bond.
Okay. All right. Well, Mr. King, since the alleged victim's not here, I'm inclined to go ahead and grant a continuance because of the fact that he's out on bail now. Have you discussed that possibility with the client, or with the alleged victim?
No, Your Honor, we've not had an opportunity to do that.
All right. Well, we have another pretrial scheduled next week, so I'm just going to leave it on the docket for then. And you can file your motion, and you can notify the alleged victim and explain to them that there is going to be a request for continuance, and that given the fact that Ms. Hapner was just appointed and just met Mr. Riffle for the first time today, that would be somewhat problematic for it to go forward that quickly. So if they have an objection, then give them the opportunity to be here for the hearing and voice that objection, okay?
Yes, sir, Your Honor.
All right, thank you. All right, next week then, Mr. Riffle. Thank you. All right, are you Sarah Kennedy appearing there from the jail?
Yes, sir.
All right, this is case number 22 CR 218, State of Ohio versus Sarah Ann Kennedy. This is a hearing being conducted by Zoom. Pre-trial, she is appearing from the jail. Her attorney is Danielle Witt, appearing from her office, appearing from the prosecutor's office, Assistant Prosecutor King. Defendant is charged with aggravated possession of methamphetamine. This matter is set for trial on December 13. I've been presented with a plea offer, Ms. Kennedy, which indicates you're going to withdraw your not guilty plea and plead guilty to the charge. I'm going to hold that first page of that agreement up to the screen. Camera, do you recognize that document that I'm looking at, that you're looking at?
Yes, sir.
All right, and on page 3, there's a sentence that reads, I enter this plea voluntarily. About a quarter of the way down the page, and right below that appears to me signature Sarah Kennedy. Hold that up to the camera. Is that your signature?
Yes, sir.
When did you sign this document, Ms. Kennedy?
When?
Yes.
Either, I think I might have signed it today. I'm not real sure. I know I signed something.
All right. Well, did you understand that was an agreement to plead guilty?
Yes, sir.
And did Ms. Witt go over that with you before you signed it?
Yes, sir.
And did she explain it to you and answer any questions you had?
Yes, sir.
All right. And do you feel you had enough time to fully consider the matter before making this decision?
Yes, sir, but I mean, honestly, I would like to ask a question if allowed.
Okay, of your attorney or of me?
Of you.
All right, what is that?
Upon the plea agreement, and I realize it's community control and a referral to drug court, but instead of a referral to drug court, can I just do community control?
Well, we're not quite, I'm going to explain that to you, but to answer your question, drug court, you have to file an application for that. You'll be referred there and they'll talk to you, but if you don't want to apply for it, that is up to you. Court cannot make you go into drug court, by court order. It's a voluntary plan. It's a better plan for people than community control, but that will be up to you. So that's the best way I can answer that.
So, will I be held up, like if you were to release me today on community control, would I be?
You won't be today. We can't grant you community control today. You're getting way ahead of it. Here's what will happen.
Sorry.
If you're not ready, I can go ahead and just let you talk to your attorney and do another case here. So if you have these questions, let me put you into the breakout room with your attorney. You talk to her, and while you're talking to her, I'll take care of another case.
I'm sorry to interrupt you, but I'll go ahead and plead guilty.
No, I don't want you to do that. I want you to talk to your attorney first before we do that, just to make sure that you understand everything. So I'm going to put you and her into a breakout room here. There's going to be a button that's going to pop up there that says join breakout room, and you'll need to click on that, and then it'll just be the two of you in there, and while you're talking, the deputy will step out. And then when you're done, you click leave the room or end the meeting, and then it'll click back on to come back in, okay?
Yes, sir.
All right. Momentarily. 92, State of Ohio versus Justin Kyle Anderson. You're Justin Kyle Anderson, appearing there from the probation department?
Yes, sir.
All right, this is a pretrial. Mr. Anderson is represented by William Rapp and Mark Wazorek, both of whom are appearing on separate screens. This is a Zoom hearing, as I indicated. Appearing on behalf of the state is Assistant Prosecutor King. This is a pretrial, as indicated. Mr. Anderson has been indicted along with looks like 6 other co-defendants. There's a total of 32 counts. Looks like Mr. Anderson is indicted on all of those except 27, 28, 20, 30, and 31. All right. Now, this is the first pretrial, final pretrial set for December 13, and we have a trial date of January the 8th. I see the state has filed their compliance with discovery, the bill of particulars, and you've received that, counsel?
Your Honor, I have received a paper copy. As you are probably aware, the documents listed on here are 238 plus 40 witnesses plus 9 experts. And then there's a couple lab reports not attached. But I believe my co-counsel Mark has dropped off an external hard drive for purpose of copying all the additional discovery, which I would anticipate we would receive soon.
Thank you, Your Honor. It's actually been mailed to the prosecutor's office.
All right. Okay. Your discovery then will be due by the final pretrial on December 13, as long with any pretrial motions. Do you anticipate any pretrial motions at this juncture?
At this time, Judge, if I may, it's a little hard to tell, but I would
Sure.
rule out maybe a motion to eliminate, potential motion to suppress, but we'll get that squared away once we review the discovery.
All right, thank you. All right. So the defense discovery will be due by the final pretrial and any pretrial motions. And has there been a written plea offer provided yet?
There has.
Okay. And is your client aware of it?
He is.
All right. All right, are there any other matters need to be brought before the court at this time?
Not from the state.
All right. Thank you, counsel. Then you can go ahead and sign off then.
Thank you, Judge.
Your Honor, would a final pretrial, would that normally also be held by Zoom, or is that attendance required?
It can be by Zoom. If that's what you prefer, just let us know.
All right, thank you very much.
Thank you, Judge.
Sure. All right, case number 22 CR 218, State of Ohio versus Sarah Ann Kennedy. All right, now the record will show that they've both Ms. Kennedy and her attorney have an opportunity to confer. Ms. Witt, is forward, or you need to put this off and have further time to talk with your client?
No, Your Honor, she relayed that she is ready to proceed.
Okay. Is that correct, Ms. Kennedy?
Yes.
All right. Now, did you sign this agreement voluntarily?
Yes, sir.
And do you wish to go forward with it today voluntarily?
Yes, sir.
All right. Now, the agreement states on page 1 that you're going to plead guilty to the charge of aggravated possession of methamphetamine, a 5th-degree felony. It further states you understand that carries a possible prison term of 12 months, possible fine of $2,500, and a possible license suspension of 6 months to 5 years. Do you understand that?
Yes, sir.
Are you facing any felony charges anywhere else?
No, sir.
Are you currently on probation, community control, parole, or post-release control for a felony?
No.
Right now, under the law, you should be convicted of this offense and sentenced to a prison term. Once you complete that term, the Adult Parole Authority may put you under what's called post-release control. It's at their option. If they do, you'll be supervised by a parole officer for the term set, and if during that period of time they determine that you have failed to comply, they could return you to prison and make you serve an additional period of up to half of your prison term for one or more violations. But if you commit a new felony, then in addition to whatever sentence the judge in the new case can impose upon you, that judge is also authorized to sentence you, in this case, to an additional period of a year whatever time is left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively the sentence in the new case. Do you understand that?
Yes.
All right, now, under the law, I'm not required to sentence you to prison for this offense. I could impose what's called community control or probation, meaning instead of going to prison, you'd be under the supervision of a probation officer for a period of up to 5 years under the terms set by the court. If during that period of time the probation department felt that you were not complying, they would file a written notice of that with the court. There would be a hearing. If the outcome of that hearing was that you'd failed to comply, then at that time the court could revoke your community control and then sentence you to prison for a period, as I said, 6 to 12 months, fine of $2,500. You understand that?
Yes, sir.
Right now, the charge alleges that on or about May 21, 2022 in this county, you did knowingly obtain, possess, or use a Schedule II controlled substance, to wit, methamphetamine. So that's the charge. Now, you understand that charge and the possible penalties?
Yes, sir.
And have you, and let me back up. Ms. Witt, you and your client are both in agreement this matter can be conducted by Zoom rather than an in-person appearance.
Yes, we are.
And you're all right with that, Ms. Kennedy?
Yes, sir.
All right, thank you. Now, have you discussed the charge, the evidence in the case, the possible legal issues in the case, possible defenses you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes, sir.
And are you satisfied with her advice and confidence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Have any promises been made to get you, have any threats been made to get you to plead guilty?
No, sir.
Now, on page 2, there's a couple of lines that say, defendant will enter a plea of guilty to the indictment, state defense jointly recommend community control, referral to drug court. Other than that, has anyone promised you anything to get you to plead guilty here today?
No, sir.
Now, under the law, the matter of sentencing is up to the judge, not the parties, and so even though you and your attorney and the state are all saying you should get community control or probation, that's not binding on the court. Once I've heard all the information, if I decide that's not the correct sentence, you could get incarcerated for a term of 6 to 12 months, have a fine of $2,500, and have your license suspended for 6 months to 5 years. Do you understand that?
Yes, sir.
Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession?
No, sir.
Now, you have certain constitutional rights you must understand before I can accept a plea from you. First, you have a right to have an attorney, and Ms. Witt was appointed to represent you. That wasn't simply to work the case out, but to provide any defense that may be available to you under the law that you would like her to provide. So if you do decide you do not want to do this, that you would rather defend against the charge, she'll continue to represent you and defend you, including a trial, if that's what you want. You understand that?
Yes, sir.
Now, under the Constitution, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After those folks are 12 of those folks are selected, the evidence would be presented, and then the judge would instruct them on the law. And then that jury would decide by unanimous verdict, meaning all 12 would have to agree, on whether or not the state proved your guilt. Now, if you decided that you did not want to have a jury trial, but you did not want to plead guilty, you could waive in writing, which means to give up, your right to have a jury trial. And in that case, you would have what's called a court or bench trial. And that means that instead of a jury hearing the evidence, the judge would hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proved your guilt. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to confront the witnesses against you in open court and to cross-examine them through your attorney. So what that means is that the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else is present. After the judge, or after the state is done asking questions, your attorney has a right to ask questions. That's called cross-examination. And the purpose of that would be to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
All right, now under the Constitution, you have a right to use the power of the court to compel or force witnesses to come into court to testify for you, the same as the state. So if you have witnesses that you're not certain are going to come in voluntarily, at your request, the court will issue a court order. It's called a subpoena. And that forces those people to come to court, be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come to court to testify against you. Do you understand that?
Yes, sir.
All right, now under the Constitution, You have a privilege against self-incrimination. What that means is it's the state nor the court can force you to testify at any time. You cannot be forced to testify. It's up to you. And if you do not testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to comment about it, with one exception. If there's a jury trial and you do not testify, the judge instructs the jury that because that's your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Right now, under the Constitution, you're presumed innocent of this charge until proven guilty by the state of Ohio on every essential element. What that means is that the burden of proof isn't on you to try to prove you're not guilty. The burden's on the state to prove you are. In fact, at trial, you don't even have to put on any evidence. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt by proof beyond a reasonable doubt, which is the highest burden of proof that's known on every essential element of the offense charge, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Originally, you pled not guilty to the charge. That denied the allegation in the indictment, denied you committed any crime, and then exercised or invoked all the rights that I've just described. If you change your plea from not guilty to guilty, that is the complete opposite of the not guilty plea. The guilty plea admits the allegation in the indictment, admits that it's a crime and that you committed that crime. And that plea waives or gives up all of the rights that I've just described for you, except your right to have an attorney. You always have a right to have an attorney, no matter what your plea. But with that exception, your plea of guilty would waive or give up your right to a court or bench trial. Waive or give up your right, and to a jury trial. It would waive or give up your right to have to confront witnesses against you in open court and cross-examine them through your attorney. It would waive or give up your right to use the power of the court to compel witnesses to be in court to testify for you, the same as the state. It would waive or give up your privilege against self-incrimination, because if you say you're guilty, that's what usually defines you guilty. It would waive or give up your presumption of innocence, because if you say you're guilty, the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives or gives up any right to file an appeal you think you may have had up to this point in the case. Now, if I should sentence you to the maximum sentence, or under other circumstances you could file an appeal, that would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen?
Yes.
Now, do you have any questions about the charge or the possible penalty?
No, sir.
You understand it?
Yes, sir.
You have any questions about the plea agreement?
No, sir.
You understand it?
Well, I'm sorry, sir. Well, I'll let my attorney proceed, but no, sir, I'd like to continue.
You would like what?
Would like to continue, please.
You want to continue the case? You don't want to go ahead and plead today?
Yes, I'd like to plead. I'm sorry.
Okay. So, do you have any questions then about the plea agreement?
No, sir.
And you understand it?
Yes, sir.
And you have any questions about the constitutional rights I've explained?
No, sir.
You understand that?
Yes.
Have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No, sir.
Now, is there anything else you would like to speak to your attorney about before we go any further?
No, sir.
All right. You have any other questions about anything that I've explained to you here today?
That I can ask you?
Yes, that's why I'm asking you if you have any questions.
Okay, yes, sir. Is there any way, I already talked to my attorney about it, but I guess my big mouth's going to get in the way. Is there any way I could just do community control and get released today?
No.
Okay.
Okay. We have to have we'll have to have a pre-trial report, or a pre-sentence report, and you have to be evaluated for treatment, so that's not going to happen today. All right, have any other questions?
No, sir.
All right, then is it your decision to go forward and plead guilty according to the terms of this agreement?
Yes, sir.
All right, then as to the charge in the indictment that alleges that on or about May 21, 2022 in this county, you did knowingly obtain, possess, or use the Schedule II controlled substance, to wit, methamphetamine, in violation of Section 2925.11 of the Ohio Revised Code, charge of aggravated possession of methamphetamine, a fifth-degree felony, carrying a possible sentence between 6 and 12 months incarceration, a fine of $2,500, and a license suspension of 6 months to 5 years. How do you plead? All right, the court finds on this day in open court, defendants advised of all of our constitutional rights, made no intelligent voluntary waiver of the same pursuant to Criminal 11. Please accept an order filed. Defendants found guilty of the charge. Court refers the matter to the Probation Department for a pre-sentence investigation report, which will include an assessment for substance use and/or mental health issues and possible treatment. Cases referred to the drug court. The defendant is remanded on bond. The bond will be continued. And sentencing will be on December 13th at 9 a.m. All right, anything further from council?
No, Your Honor.
All right, Ms. Witt, are you going to be around in about an hour?
Yes, I can be.
I'd like you to come over here maybe around 2:30 or 2:45, and I want to see Mr. King as well.
I'm sorry, actually, I'm in Adams County. I thought you meant by Zoom.
Oh, okay. Are you going to be in the morning?
Yes. Yes, I will be.
Okay. I don't think I have much tomorrow, do I? Oh, wait a minute.
Municipal court is my only thing in the morning.
I have, let me see what I've got here. I have the calendar here. Ms. Brooks, are you Bridget Brooks appearing there from the probation department screen?
Yes, sir.
All right, this is case number 23 CR 195, State of Ohio versus Bridget M. Brooks. This is a pretrial being conducted by Zoom. Ms. Brooks is appearing from the probation department. Her attorney is Jeffrey Blosser, appearing from his office by Zoom. Appearing from the prosecutor's office also by Zoom is Mr. King. Defendant is charged along with 6 other co-defendants. I believe she is charged in counts 25 and 26 with trafficking and possession of hashish, trafficking in the vicinity of the school zone, first and second degree felony. The matter is a first pretrial. Final pretrial set for December 15. Trial is set for January the 8th. It looks like the state has provided discovery and also requested discovery. You've received that, Mr. Blosser?
I have, Your Honor.
All right. And your discovery will be due then by the final pretrial. Do you anticipate any pretrial motions?
I do not. I've prepared the response to the state's discovery request, and then speaking with Ms. Brooks and conveying the offer from the state. It's my understanding just a short time ago that she intends to enter a plea, so we just need to go over the paperwork, get that to the court, and then maybe we could do that even before the final pretrial.
Okay. Yeah, that would be good if we could, because that's going to be a pretty busy day. Okay. Then stay in touch with your attorney, Ms. Brooks, and if you decide you want to do that, we'll try to get this set up in the next couple of weeks according to everybody's schedule. Okay? Thank you.
Thank you.
All right, Terry Barnes will be next. All right, are you Terry Barnes appearing there from the jail?
Yes, sir.
I'm sorry, from the probation department. All right, this is case number 23 CR 158, State of Ohio versus Terry W. Barnes. This is a pre-trial being conducted by Zoom. Mr. Barnes is appearing from the probation department. Appearing on behalf of the defendant, this is attorney Dennis Kirk, who's appearing by Zoom from his office. Appearing on behalf of the state from his office is Assistant Prosecutor King. The defendant is charged with felonious assault and tampering with evidence, and this is a final pretrial. The trial is set for December the 4th. Now, Mr. Kirk, do you and your client both agree to this matter being conducted by Zoom rather than him appearing in person in the courtroom?
Yes.
You're all right with that, Mr. Kirk?
Yes, sir.
All right, your client, and you're all right, Mr. King, or Mr. Barnes, with that?
Yes.
All right. Now, Mr. King, has the alleged victim of the offense been notified of the time, place, and purpose of this hearing, the right to be heard? You're muted, Mr. King.
Yes, he has, Your Honor. I believe he's monitoring this hearing on the screen, Mark K. Conrad, or he either is trying to be admitted. I don't know, can you tell if anyone else is trying to be admitted right now to the conference?
Well, let me see here. Yes, there are two people trying to get admitted. One's Miss Barber, and one is Highland County victim witness. Thank you. I saw that a minute ago, but it went off the screen, and I thought it meant that they had closed off, but apparently not. All right. All right, so is that the individual then on the screen with this marked Highland County victim witness?
Yes, Your Honor.
All right. Now, I have been presented with a plea of guilty form, a waiver of prosecution by indictment, and a bill of information. Currently, Mr. Barnes, you're charged in the indictment with a second-degree felony, which if convicted would carry a possible prison term, that's in count one, felonious assault, of 2 to 8 years as a minimum, and a maximum of up to 50% of whatever sentence is ordered by the court that could be added by the DRC. And you're also charged with tampering with evidence, a third-degree felony, which carries a possible prison term between 9 and 36 months in the levels provided by law. It goes 9, 12, and then every 6 months up to 36 months. And there's a fine available of $10,000. Now, I have here before me a plea of guilty form, which indicates that you're going to plead guilty to a bill of information on the offense of aggravated assault, which would replace, I assume, the felonious assault charge, correct, Mr. King?
Yes, Your Honor.
All right. And enter a plea of guilty to that by a bill of information. Now, a bill, under the law, Mr. Barnes, no person is required to appear in front of this court to answer to a charge of a felony unless that charge, that case has been submitted to the grand jury and the grand jury has returned an indictment. The grand jury consists of 9 people who meet once per month to hear evidence about alleged violations of the law in the county. They do not make a decision as to guilt or innocence, but simply a decision as to whether or not there's enough evidence to warrant the case coming to court. And so therefore, only 7 of those 9 must vote to return an indictment. And so that has not happened on the aggravated assault case. You're simply facing the felonious assault charge. However, there's a provision under the law that a person can waive or give up their right to have the charge considered by the grand jury and agree to proceed by what's called a bill of information. Now, a bill of information is basically the same thing as an indictment. It sets forth what the charge is. But the difference is the grand jury didn't hear it and vote on it. It is simply signed by the prosecutor and takes the place of an indictment. And so that's what's been proposed here for an aggravated assault. And that bill of information reads that on or about August 4, 2023 in Highland County, Ohio, you did while under the influence of sudden passion or a sudden fit of rage, either of which was brought on by serious provocation occasioned by V, which stands for the alleged victim, that was reasonably sufficient to incite the said Terry W. Barnes into using deadly force, did knowingly cause or attempt to cause physical harm to V by means of a deadly weapon or dangerous ordinance as defined in section 2923.11 of the Ohio Revised Code, to wit a knife, in violation of 2903.12A2 ORC, aggravated assault, felony of the fourth degree. And so that's the proposed charge. And then there's also a waiver of prosecution by indictment, which says that you've been informed by the court of your constitutional right to be prosecuted by way of indictment, and that being represented by Mr. Kirk, you freely and voluntarily have waived that right to be prosecuted by a bill of indictment and agree to proceed by bill of information. I'm going to hold that up to the screen and ask if you recognize that document and if that's your signature there on that document.
Yes, sir.
All right, do you remember when you signed that? It says today. Was that this morning you signed it?
Yes.
Okay. Now, Mr. Kirk King is the alleged victim of this offense in agreement with this disposition.
My understanding, he's not, Your Honor. The state has consulted with him. The state has explained to the alleged victim the reason for this plea offer. And despite all of that, it's my understanding he's opposed to this plea agreement.
Okay. All right. So this plea agreement I've been presented is 3 pages, and in page 1 is the plea of guilty form. I'm going to hold this up to this camera, Mr. Barnes, and ask if you can recognize that. Has your name, case number, and says that you're pleading guilty to the bill of information. Do you see that?
Yes.
You recognize it?
Yes, sir.
All right, and then on page 3, at the top of the page, there's a sentence that reads, I enter this plea voluntarily. Right below that appears to be the signature of Terry W. Barnes. Is that your signature there?
Yes, sir.
And did you sign this today as well?
Yes, sir.
Now, when you signed it, did you understand that it was an agreement to plead guilty, which means there won't be a trial, and the next step in the case would be a sentencing hearing?
Yes, sir.
And did you have enough time to fully consider this matter before making this decision?
Yes, sir.
Do you think that you've been rushed or pressured in any way into doing this?
No.
And did you enter into this agreement and sign this agreement voluntarily?
Yes.
Are you, all right, now the agreement states, as I said, is you're pleading guilty to the bill of information, and it has as a potential punishment a prison term of between 6 and 18 months and a fine of $5,000. You understand that?
Yes, sir.
And are you facing any felony charges anywhere else?
No.
Now, are you currently on probation, community control, parole, or post-release control for a felony? And other than this case?
No.
All right. Now, under the law, if you should be convicted of this offense and if you should be sentenced to a prison term, once you complete the prison term, it is possible the Adult Parole Authority may put you into what's called post-release control supervision for a period of up to 2 years. They don't have to, but they can. If they do, you'll be supervised by a parole officer in the terms they set, and if during that period of time they determine that you have failed to comply, they can return you to prison to make you serve an additional period of up to half of your prison term for 1 or more violations. But if you commit a new felony, then in addition to whatever sentence a judge in the new case could impose upon you, the judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year or whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that must be served consecutively to the sentence in the new case. Do you understand that?
Yes, sir.
Now, I'm not required to sentence you to prison for this offense. I can grant what's called community control or probation, which means that instead of going to prison, you'll be put under supervision of a probation officer for a period of up to 5 years on a term set by the court. If during that period of time, the probation department felt that you were not complying, they would file a written notice of the court. There would be a hearing. If the outcome of that hearing was that you had failed to comply, then at that time, the court could revoke your community control and then sentence you to prison after a hearing where you're represented by counsel for between 6 and 18 months and fine you $5,000. Do you understand that?
Yes, sir.
All right, now the bill of information, I just read that to you a minute ago. Do you understand what it is the state has accused you of having done, when, where, and how they alleged you did it?
Yes, sir.
And you understand the possible penalty for that?
Yes, sir.
Have you discussed the nature of the charge, the evidence in the case, the possible legal issues in the case, the possible defenses you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes,
Are you satisfied with his advice and competence in this matter?
absolutely.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
All right, now on page 2, there are several lines printed in bold that read, the defendant shall enter plea of guilty to the bill of information. State will dismiss count 1 and count 2 of the indictment. State defense will argue sentencing. Defendant agrees to make full restitution. Is that your understanding of the agreement?
Yes.
And no one's promised you anything other than that to get you to plead guilty here today?
No.
All right, now at this time, if the alleged victim of the offense would like to make a statement regarding the plea offer, the court will hear that.
Yes, sir.
You want to state your name, please?
My name is Richard Hunt.
All right, and so you're the alleged victim of this offense?
Yes, sir.
All right, and if you want to state why what your position is on the plea agreement that state's offered?
The man come to my house with a knife open. I walked outside, asked him what he was doing, and I got stabbed.
Well, my question is not about what happened that night. My question is, what is your objection to the alleged plea agreement?
I feel like he should get more prison time. He gutted me like a fish. I've lost my work. I'm on the verge of losing my home. He literally gutted me from my waistline to my sternum.
Okay, again, I'm not asking about what happened at the trial or at the event, but the alleged event, but you know, the reasons for it. So I understand you think that he should get more time than what would be provided for in this charge. Is that your objection?
And I live just a couple houses down from him. And, you know, I'm living in fear now.
All right.
And I've lost work. My child's support going behind. You know, this has destroyed my life. And
All right. Okay, I don't want you to get into all the other stuff, so.
Come to my property
All right.
with
I think I've heard enough, Mr. Hunt. Now, Mr. King, if you want to explain what the state's position is and why going forward with this plea agreement over the objection of the alleged victim.
Yes, Your Honor, upon reviewing the evidence in the case, the state will not be able to get a conviction for felonious assault, particularly in light of the alleged victim's conduct at the time of this incident, leading up to and during the stabbing. Without litigating the case right now, the state just doesn't, it's the state's position that there's no way we would get a conviction on a felonious assault in this case, Your Honor.
Okay. All right. Well, in consideration of everything, the court is going to go ahead and move forward. And you, Mr. Kirk, you and your client are wanting to go forward with this agreement.
Yes, Your Honor.
Is that correct, Mr. Barnes?
Yes, sir.
All right. Now, do you hold any license or certification from any state governmental agency that regulates any occupational profession?
No, sir.
Now, you have certain constitutional rights, which I understand, before I can accept your plea. First, you have a right to have counsel, and if you cannot afford to hire counsel, court would appoint one for you. I can't remember. Are you appointed in this case, Mr. Kirk?
I am, Your Honor.
Yes, okay. All right. Now, Mr. Kirk wasn't appointed simply to work the case out, but provide any defense that could be available to you under the law that you'd like him to provide. So if you decide you do not want to do this, that you would prefer to defend against the charge, then he would continue to represent you, including a trial, if that is what you want. Do you understand that?
Yeah.
All right. Now, under the Constitution, you have a right to have a jury trial in this matter, in which 12 people will be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After they are selected, the evidence will be presented. The court would instruct that jury on the law, and then that jury would decide by unanimous verdict, meaning all 12 would have to agree on whether the state proved your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive, which means to give up in writing, your right to have a jury trial. And in that case, you would have what's called a court or a bench trial, which means that instead of a jury hearing the evidence, the judge would hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proves your guilt. Do you understand that?
Yes.
All right, now, under the Constitution, you have a right to confront the witnesses against you in open court and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into court, testify in front of you and your attorney and anyone else is present. After the prosecutor's done asking questions, your attorney would ask questions. That's called cross-examination, and the purpose of that would be to bring out evidence that helps your side of the case. Do you understand that?
Yes.
Now, under the Constitution, you have a right to use the power of this court to compel or force witnesses to come into court to testify on your behalf, the same as the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order, that's called a subpoena, and that would force those witnesses to come into court to testify on your behalf, just like the state, which is, again, the same way the state's witnesses are required to come to court to testify against you. Do you understand that?
Yes, sir.
Under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can, it's up to you. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to comment about that except in one situation. If there's a jury trial and you don't testify, the judge instructs the jury that because it is your right, they cannot consider it for any purpose. Do you understand that?
Yes.
Right now, under the Constitution, you have a privilege against self-incrimination, which means that you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can, it's up to you. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to comment about it except in one situation. If there's a jury trial and you don't testify, the judge instructs the jury that because that's your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Now, under the Constitution, you're presumed innocent of this charge until proven guilty by the state of Ohio on every essential element of the offense charged. What that means is that the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused. In fact, under the law, you're not required to present any evidence at all in your own defense. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
All right, now originally you entered a plea of not guilty, Mr. Barnes. That plea denied the allegation in the indictment, denied you committed any crime, and it exercised or invoked all the rights that I've just described for you. If you change your plea from not guilty to guilty, that is the complete opposite of the not guilty plea. The guilty plea will admit the allegation in the indictment, admit that they constitute a crime, that you committed that crime. And that plea will waive or give up all of the rights that I've just described for you, except your right to have an attorney. You always have a right to have an attorney no matter what your plea, but with that exception, your plea of guilty waives or gives up your right to have a jury or court trial, waives or gives up your right to confront witnesses against you and cross-examine them through your attorney. It waives or gives up your right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, same as the state. It waives or gives up your privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives or gives up any right to file an appeal you think you may have had up until this point in the case. Now, if I should sentence you to the maximum sentence or under the certain circumstances you can file an appeal, that would have to be filed within 30 days of your sentencing entry being filed. Do you understand that?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
All right. And you entered into this plea agreement voluntarily.
Yes, sir.
All right. Now, do you have any questions about the bill of information, the procedure by which this charge is being brought before the court today?
No, sir.
You understand it?
Yes.
You have any questions about the plea agreement?
Yes, sir.
Well, do you have any questions first?
No, I'm sorry.
Okay.
No, sir.
And you understand it?
Yes.
Have any questions about the constitutional rights I've explained?
No, sir.
You understand those?
Yes.
Have any questions about the plea of guilty, what it means, or what will happen if you enter that plea here today?
I understand, yes.
All right. Is there anything you need to speak with your attorney about before we go any further?
Yeah, just for a second.
All right. I'm going to put you into a breakout room then, where just the two of you will be on the screen. No one else will be able to see you or hear you, and so that can be confidential. So let's see. There's going to be a button pop up there momentarily that says enter breakout room. You click on that, and then when you're done, you click on leave it, and then there'll be another button you'll have to apply to be readmitted into the meeting. So that should pop up on your screen just momentarily. All right. Now, Mr. Kirk, you and your client confer, are we going to go ahead and go forward?
Yes, we are. I believe I answered his question and he's
All right.
prepared me forward.
All right. All right, then, Mr. Barnes, is it your decision to withdraw your not guilty plea and plead guilty to the bill of information charging you with aggravated assault pursuant to the terms of the plea agreement that we've gone over here today?
Yes.
All right, then, as to the charge which alleges that on or about August 4, 2023 in Highland County, Ohio, you did, while under the influence of sudden passion or a sudden fit of rage, either of which is brought on by serious provocation occasioned by V, which is the alleged victim, that was reasonably sufficient to incite the said Terry W. Barnes into using deadly force, did knowingly cause or attempt to cause physical harm to B by means of a deadly weapon or dangerous ordinance as defined in section 2923.11 of the revised code, to wit a knife. In violation of 2903.12A2, the offense of aggravated assault, a felony in the 4th degree, carrying a possible prison term between 6 and 18 months and a fine of $5,000. How do you plead? How do you plead?
Guilty.
All right, thank you. Court finds on this day in open court, defendant is advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to Criminal Rule 11. Please accept and order filed. Defendants found guilty of the bill of information, and the indictment will be dismissed. The court orders the matter be referred to the probation department for a pre-sentence report. Bond will be continued, and the court will set the sentencing for January the 3rd at 9 a.m., and that'll be in person.
Your Honor, I'm not in the office on that day.
Well, I'm not asking you to be in the office, I'm asking you to be here.
Okay.
You're gonna be busy, I take it.
Correct.
All right.
Yes. I'm available the 4th or thereafter.
All right. January the 4th at 1 o'clock then.
Thank you, Your Honor.
All right. Thank you. You can go ahead and go, Mr. Barnes, and Mr. Arjim will have you make an appointment for your pre-sentence interview. And you'll be coming to court in person on your next hearing.
Okay.
All right, this is case number 23 CR 197, State of Ohio versus James Stephen Fetro. Are you James Stephen Fetro appearing there from the probation department?
Yes.
All right, Mr. Fetro is charged with 6 co-defendants. He's only charged on 1 count of a 32-count indictment, count 30 permitting drug abuse, and then also a forfeiture in count 31. This is a first pretrial, and I believe this matter is set for the 8th of January for trial, and a final pretrial on the 13th of December. I see the state's provided discovery, and have you received that, Mr. Wagner?
We have, Your Honor, a mass amount on a 1 terabyte drive. We're still going through it.
All right. Do you anticipate any pretrial motions?
Not at this point, sir.
All right. Your discovery or any pretrial motions will be due by the final pretrial, and has there been a written plea offer provided?
We've got it. I've not got it to Steve yet, Your Honor.
All right. All right, Mr. Vetra, you want to get in touch with your client, or your attorney, so he can discuss that with you and the other matters in the case. All right. Anything further from counsel?
No, sir.
All right, thank you.
Thank you, Your Honor.
Christopher Eaton appearing there from the jail?
Yes.
All right, that's case number 22 CR 151, State versus Christopher J. Eaton. Mr. Eaton's appearing by Zoom from the probation department. His attorney is Sarah Barger, appearing from her office. Appearing from the prosecutor's office is Assistant Prosecutor King. Looks like the defendant has been charged in count 15 and 16 of this indictment with 3 other co-defendants. He's charged with aggravated trafficking and aggravated possession of methamphetamine. This is a first pretrial, final pretrial set for the 13th of December, and January 8th is the trial date. Now, Ms. Barger, I see that they provided a bill of particulars and discovery. Have you got each of those?
He received a plea offer, but I have not heard from my client.
Okay. All right, your discovery and any motions will be due by the final pretrial. And Mr. Eaton, you'll need to get the phone number for Ms. Barger there from the probation department and give her a call so she... Pardon me?
Is that a number?
Yes.
Okay.
I've been sick with COVID, that's why I've not been able to call her.
All right, well, you can call her tomorrow then. All right. And make sure you get in touch with her because our next hearing is the 13th of December. All right? Thank you. All right, this is case number 23 CR 198, State of Ohio versus Melanie Ann Anderson. Are you Melanie Ann Anderson appearing there from the probation department?
Yes.
All right. This is a pretrial being conducted by Zoom. The Defendant's represented by Sarah Barger, who's appearing from her office, and appearing from the prosecutor's office, Assistant Prosecutor King. Defendant is charged in 3 counts of a 32-count indictment with other co-defendants. She's charged with 2 counts of permitting drug abuse and 1 forfeiture specification. This is a first pretrial, and I see that the state provided discovery and a bill of particulars. Have you received those, Ms. Barger?
Your Honor, just as Mr. Wagner said, it's a terabyte of information to go through.
I'm having trouble understanding you.
I have received it, it's just a lot of information to go through. It's a
Okay.
terabyte of information.
All right. Well, your discovery will be due by the final pretrial. Do you anticipate any pretrial motions?
Not at this time.
All right. Has there been a written plea offer provided?
There has, Your Honor.
All right. All right, is there anything further to come before the court on this matter?
No, Your Honor.
No, Your Honor.
All right. Then stay in touch with your attorney, Ms. Sanderson. Thank you. All right. All right, are you James C. Bishop appearing there from the probation department by Zoom?
Hi.
All right. This is case number CR 179, State of Ohio versus James Charles Bishop. This is a pretrial being conducted by Zoom. Mr. Bishop's attorney is Dennis Kirk, who's appearing from his office. Appearing from the prosecutor's office, Assistant Prosecutor King. Mr. Bishop is charged with aggravated trafficking and aggravated possession of methamphetamine. This is a first pretrial, final pretrial set on December 13, a trial date of January 25. Now, I see that the state provided discovery and a bill of particulars. You received that, Mr. Kirk?
I have, Your Honor.
All right. I don't see your, have you filed your discovery yet, or?
I don't believe I have so yet, Your Honor.
No, okay, so it'll be due by the final pretrial. And do you anticipate any pretrial motions?
Not at this time.
And has there been a written plea offer provided?
There has, and my client has been made aware of it.
All right. All right, are there any other matters need to come before the court at this time?
No, Your Honor.
I see, Mr. Bishop, that there's been a bed for you made available at the Recovery Council. Is that the Massey House, or where is that, Mr. Arshima?
Waverly County. Waverly County.
Oh, okay, down in Waverly?
Yeah, Pike County.
Pike County Recovery? Okay. All right. Right, you go ahead and go, and we can make arrangements to do your next hearing by Zoom down there. We do it all the time. All right. Okay, thank you. You can go ahead and go, Mr. Bishop. Thank you. All right, this case number 23 CR 163, State of Ohio versus Robin Spring Robinson. You're Robin Spring Robinson?
Yes, John.
All right, Ms. Robinson, you were arraigned back on October the 5th on the charge here of illegal conveyance and aggravated possession of meth. You indicated you were going to employ counsel. Do you have an attorney in this matter?
My mom's getting money in 2 weeks, 3 weeks. My sister and her's getting together to get money to get my lawyer.
And have you talked to a lawyer yet?
I've already talked to him. I talked to him.
And who is that going to be?
Bill Rapp, William Rapp.
All right, but you haven't got the money to him yet.
No, I haven't, Michael.
Okay, well, you know, this matter's set for a final pretrial on December 13th, and you've had now, you know, over a month to get that together. Now, you're going to have to do it, or you're going to end up...
I'm going to have money in 2 weeks.
Okay, well, all right. You need to be back here in person on the 13th of December then.
Okay.
And if you don't have an attorney by then, I'm probably going to appoint one. Now, you're supposedly in treatment down at the Sunrise Center in Milford?
Yes,
How long you been there?
since December of last year.
Oh, so that's outpatient then?
Yeah.
All right, well, because we've got here a couple of positive tests. So I want you to go down to the probation department right now and get a drug test. All right, and Sergeant Jim and Miss Robinson should be down there shortly. If she should not make it, let me know, and we'll invite her back through the sheriff.
Yes, sir.
All right, thank you. All right, you can go ahead. All right, are you Deandra Wilkerson there at the probation department?
Yes, sir.
All right, this is case number 23 CR 157, State of Ohio versus Deandra Wilkerson. This is a pretrial. Ms. Wilkerson's attorney is Catherine Hapner, appearing from her office, appearing from the prosecutor's office, Assistant Prosecutor King. Defendant's charged with 1 count of aggravated possession of methamphetamine. This is a first pretrial, final pretrial set on the 13th. Trial date is set for the 11th. I see that the state provided a bill of particulars and discovery, and I don't think you've got yours in yet, do you, Ms. Hapner?
No, I have not.
All right.
Yet.
Yours will be due by final pretrial as per the usual policy. Do you anticipate any pretrial motions?
Not at this point.
All right. Has there been a written plea offer provided?
There has been, and that's been provided to my client.
All right. All right, are there any other matters then to discuss at this time?
No, Your Honor.
All right, thank you. We'll see you on your next pretrial. That'll be by Zoom as well on the 13th.
Okay. Guilty or not guilty today?
No.
Ms. Okay, next. I'm sorry. I contact my office and take care. Yes, ma'am. Thank you. You're welcome. Are we done?
Yeah, you're. Number 23 CR 160, State of Ohio versus Jason Lee Huffer. Mr. Huffer's attorney, this hearing is being conducted by Zoom. It's a pretrial. Mr. Huffer's attorney is Danielle Witt, appearing by Zoom, appearing on behalf of the state as Assistant Prosecutor King. Mr. Huffer is not present in the courtroom. He's not present at the probation department. According to the report I received this morning, he has not reported since November the 1st, nor has he called in to reschedule. Have you heard anything from him this morning, Mr. Arjima?
No, Your Honor.
Ms. Witt, have you had any communication from him?
I have not, Your Honor.
All right. Well, the court then will order that a capias issue for his arrest for failure to appear, and we'll put the case on the inactive docket for the time being until he is located. All right, I believe that completes the docket. Is that right? All right, thank you, everyone. Huh? Oh, wait a minute, Danielle?
Yes.
What about her? Denny.